All right. Well, welcome to the Right Launch Group. Today, we're doing a special lesson with Maria Riegger. Is that correct pronunciation, or is it?
It's Riegger. Sorry, it's a weird German name. So
All right. So she's going to talk to us about legal issues in publishing, and why don't you just take it away?
all right. I'm super excited to be here, you guys. This is these are very important topics. I see a lot of misinformation on author forums, other things. So anyway, as Tim said, my name is Maria Riegger. I'm an author. A couple of disclaimers. I have to say, nothing I talk about today is legal advice, right? I'm licensed to practice law in the state of Virginia, but some of the issues that we're talking about are state law specific. So I cannot really give any specific advice, even if I wanted to, about other jurisdictions. I practice corporate transactional work during the day. I do not litigate. So I do not litigate these issues in my day job. So I just want to make that clear. I am a self-published author, though, and I'm very familiar with what we're going to talk about today. So most authors ask me about defamation and copyright stuff. And Timothy mentioned one of the main areas you guys wanted to know about was what you can and cannot put in memoirs and nonfiction books. So, I mean, you can put whatever you want, right? So the question is, how do you can't really prevent getting sued because unfortunately it's pretty easy to bring a frivolous lawsuit, but you certainly can mitigate and reduce risks of suit. So when you are writing nonfiction, you are, and you're writing about real people, you are, want to be thinking about risks of defamation suits. Okay, so when a plaintiff brings a defamation suit, they have to show that you published this. We're talking about written defamation. You published a defamatory statement about them that is false. What is defamatory? Well, again, this is a state law issue, so that can vary, but it's generally something very negative, like he's an abuser or they got a DUI. It's something negative that affects that person's ability to hold or keep a job. That's a good kind of general way of thinking about it. Now, truth is a defense to defamation. So whatever true statements you say about somebody, that's not defamation, right? But if you are sued for defamation and you're stuck litigating the matter of truth, obviously that is costly. So it's something you're going to have to think about when we talk about like defending, whether it's a defamation or a copyright infringement suit. There's significant costs involved with that, and that's why a lot of authors don't, mount defenses or don't sue as a plaintiff for things like infringement. So what can you do to protect against defamation suits? When you're writing nonfiction, we usually recommend you write about, if you're writing about real people, that you write about them in a way that the person could not prove that you are only writing about that specific person. That usually involves obscuring details. Instead of, writing in first person, my uncle, you could write in third person, or a creative nonfiction piece, you're writing about the character's uncle. Or you're writing in first person, but you're obscuring a lot of facts and details regarding certain characters. A lot of authors, myself included, are inspired by real people. That's not unusual. But you want to make sure you are not writing in such a way that it could only be about a specific person. Okay, that's the best thing you can do to protect yourself from a defamation suit. If it's okay, I'm going to go ahead and talk about copyright plagiarism. Do you want to break for questions about that, or anything else you guys want to know about? Okay.
I think in the chat there might have been something about creative license in terms of doing nonfiction based on memory, part fantasy nonfiction. What I remember, the characters are real, but I don't use their real names.
Right.
So Tim, that's mine. Can I just give you an example? Because I actually am involved in a major defamation suit.
Oh, wow.
Yeah, but I'm not going to go into the crazy ass details. You don't need to know because it's straight out of Dateline. But it involves me. The story's true. Mm-hmm. And I've changed the names in my books and on my websites and stuff. And I've changed like the industry, or actually I haven't changed the industry because it was like Wall Street and then it was my ex-husband and his wife, and he's now dead. I mean, the story's crazy, but I've changed all the names, and she's trying to say it's defamatory, even though the names are completely changed. I have a disclaimer on my website. Yeah, and so she's attempting to. So my question is, do I have to just completely change like the industry, like, and say that he's not on Wall Street?
I mean, it helps to obscure as many details as possible. Not knowing what jurisdiction this is in, I can't really speak to.
It's in Georgia, but it's yeah. I
can't
just
really.
I want to protect myself, but I also want to be
Sure.
able to have it be creative license that people who know my
Sure.
story, because it's true and it's
Right.
a horrific story.
Right.
And I
Right.
want people to know about it. And I get asked to go on podcasts all the time. And my lawyers have said, because this also involves a criminal element, that I've been arrested. I mean, it's crazy shit. But I've already changed everything. And she's still trying to say it's defamatory. And of course, I have a lawyer and we're going back with her. But I've also heard it's best to just not make it funny. But if there's more humor in it, they can't tie it to you. And, you know, but.
Yeah, I'm not sure about the humor element. I mean, this is a really good example of, anybody can bring a suit. So
Correct.
if I don't know if you said, I'm not sure if there's a suit that's already been filed or she's threatening suit at this point.
No, we both have suits and counter suits back to each other.
Yeah. So, I mean, your attorney's going to be able to give you the best specific advice, obviously. So, I mean, if everything you said is true and you can prove it, she's not going to win. You have to be able to prove it, right? Based on the laws of the state. So that's one thing. Now, how long it may take for you to litigate that, I don't know. I mean, you gotta have to think about that for yourself. But unfortunately, as Tim was saying at the beginning, when we first met, it's not possible to prevent people 100% from suing you. Some states have, for civil suits, a loser pays law, where if a plaintiff brings a civil suit against you and loses, the plaintiff is forced to pay your court costs. My state does not have that. I don't know if your state does.
Yep, we do.
Yeah,
so we're both going after that. And so, what does the disclaimer do? Nothing.
I mean, it helps you. It's an evidentiary piece that you bring. For example, that you can show to say, like, I stated that, this is not based on me, but real, but there are ways to get around that. It's not a foolproof thing, right? But it is an evidentiary piece, something your attorney would bring up. Look, we have this disclaimer and other things, right? But no, it's not foolproof. No.
Okay, thank you.
No problem. Sorry, that's very
I have a question, if you could.
Shoot.
I'm writing a creative nonfiction, or perhaps what you call a nonfiction novel. It deals with a couple living on a rubber plantation in Sumatra in the 1930s. The couple are my parents, actually, and so I'm well along. I'm about a little over 500 pages in the manuscript. I am using the real names of all the characters. These are characters that my mother has written about in letters. I have all these letters. In some cases, she describes their foibles and characteristics. In some cases, I'm just making up what their personalities are. These people are all dead. Most of their children are dead. A few of their children are alive, and I've corresponded with them. But my intention is to continue to use their real names and actually describe what they look like. I have photographs of all these people. So what is the risk of doing that?
So you cannot defame somebody who is deceased. So anyone who is deceased, there's little to no defamation risk there. For people who are still alive, everything we're talking about is applying. So that's like the main thing. So,
but I have been warned that their descendants might take offense at something I've written about them.
It's
Because maybe
possible.
what I write about them in terms of making up what their personality is like, maybe it's not true, because in some cases I don't know what the personality of these people are.
Right. Yeah. In most states, that's really hard to do for the descendants to bring a defamation lawsuit about
Okay.
somebody who's deceased. So, but a local attorney could be able to tell you, but that's really, most states that's difficult to do. You really can't bring a defamation case if the subject is deceased.
Right. All right. Thank you.
No problem. All right. Yeah, that's defamation. It can get a little hairy because it's state law specific.
Maria, can I ask you a quick question?
Yes, shoot.
Real quick question. You said something about, if you write somebody got a DUI, then they can sue you.
Right.
What
Well, I don't.
if
Yeah.
they actually
Well,
did get a
that's an
DUI?
example, but yeah. Sorry. Go ahead.
What if they actually did get a DUI?
Truth is defense to defamation.
Okay.
That's not defamatory. If it's true,
Okay.
if it's a true statement, it is not defamatory.
Okay.
Yeah.
Are you gonna talk about the fiction slant of it or not?
Yeah, we can definitely. So fiction,
quickly,
pretty much,
yeah.
quickly,
Go
okay.
ahead.
For fiction, same rules pretty much apply, right? There's less of a risk because it's a fiction work, but the same risks apply. Like if you are drawing a character or describing events that are so granular and specific, it can only be about one person, then there's a defamation risk. But same rules apply for fiction, yeah. Okay. I think Tim wants to move on. So he had asked about plagiarism and copyright. So you want to talk first about protecting your own copyright or using the copyrighted works of other authors? So those are the two main issues regarding copyright. We'll talk first about plagiarism and then fit into like protecting your own copyright. How about that? So plagiarism, when we talk about plagiarism, we're talking about, if you use somebody else's work and pass it off as your own, that is not an actionable civil offense. The related actionable civil offense is copyright infringement, which we've already brought up, right? So if you use somebody else's work and you either pretended it was your own, or you used their work and made clear it was somebody else's work, but you did not get permission from the copyright holder, you are at risk for a copyright infringement suit. To use copyrighted works, talk about written works, you need permission from the copyright holder. Now people usually ask, how much of a quote work can I use before I am required to request permission? There is no legal minimum. Okay, you'll have some people say in practice, well, I had people say to me, well, I used to work at a big publishing firm, and the attorney there said we could use 3 lines without having to request permission. That's not based on the law. That's based on some practice or some unofficial agreement. That's not based on the law. So what the general rule is, when you use works that are copyrighted, even if you are giving credit to the author, to the copyright holder, you are required to request permission. How do you do that? For books, you look at the front matter, see who has the copyright, write to them directly. For songs, it's a little more complicated. You have to write to the copyright holder of the songs. In my book and on my blog, I have a whole process on how to do that. So I don't want to go into it in too much detail here, because I can refer you guys to that if you're interested. But that's using other people's works. Protecting your own copyright, okay? So when you create a written work, you have copyright as the creator of the work. There is you don't have to register it with the Copyright Office, US Copyright Office, or the Library of Congress in order to assert copyright over the work, okay? Why it is a good idea to register with the US Copyright Office is if somebody uses your work, infringes your copyright, if you have registered with the Copyright Office, you are able to sue for statutory damages. That can be up to $150,000 per work. If you are a newer author or an author that has not had that much commercial success yet, that is very valuable. So that is why we recommend you register each of your works with the Copyright Office. You can assert copyright over your works when you have created them. But to get the statutory damages protection, you need to be registered with the Copyright Office.
Now, those statutory damages, does the work that was taken or used the copyright, does it have to have made money? Do you sue against that?
No. If you don't register with the Copyright Office, the damages you can seek are lost wages, lost sales, which if you haven't had that much commercial success, it's very little. But like you said, like you hinted, the statutory damages are based on statute. They're not based on sales at all. That's why it's so valuable. Another point is that copyright law is federal law under the Federal Copyright Act. If you are litigating either defending a copyright infringement lawsuit or bringing one, you have to bring it in federal court. It is more expensive than bringing it in state court. That is what somebody asked earlier. How do I prevent people from stealing my work? Really tough to prevent people from stealing your work, but when they do, you have the option to sue. But for most authors, it's cost prohibitive to bring the copyright infringement action. It's going to cost more money to bring the suit, so they just don't do it. Something you have to consider.
True or myth? I know the answer, but so many people still ask me about this myself. So if you take a bunch of your work and mail it to yourself, is it already a registered copyright?
No. This is a good point, though. There was a case recently about this, a federal case where somebody had applied to the Copyright Office, but the office had not registered their copyright work, and they sued for statutory damages. And the federal court found that no, mailing it to the Copyright Office or paying the fee is not the same as having it officially registered, because there's a delay between you applying it and it being registered, you filing and it being registered. It has to be registered to get the statutory damages. Filing is not sufficient. So that's a good point to point out. Yeah. Okay. We talked about that, talked about plagiarism. Oh, and then you wanted me to mention the class action suit that's been filed recently. That's very interesting. So a bunch of authors, including well-known authors, David Baldacci, George R.R. Martin, Jodi Picoult, filed a class action copyright infringement suit in federal court against OpenAI. So this is interesting. It's a case of first impression. The courts always lag behind technology. So we're going to have to figure out how to treat this. So the brunt of the case is, the main cause of action is, so OpenAI uses copyrighted works to train its models and create the algorithm, okay? And the authors are suing, alleging that the use of the copyrightable works, which was done without permission from the copyright holders, constitutes a written reproduction of the work, which is a copyright infringement. So that's the main question the court has to decide. The use of the copyrighted works in formulating the models, is that a reproduction of the work such that under the Federal Copyright Act, such that permission to use the copyright needed to be, secured. So I expect that as the discovery process continues and we get more information about how OpenAI models work and how the training models work, the court will be more informed to make a decision about that. But it's a pretty good argument. So because the outcome is arguably are works that may have had to have been for which they would have had to request permission from the copyright holder, or the OpenAI produced works were works of authorship, right? So it's an interesting question, yeah. But I'll be very interested to see how that kind of develops. But any questions about copyright? Because I know we went over that kind of quickly.
Yeah, interesting on that case. I mean, there's a couple of defenses, and I think one defense is the final product that AI spits out does not resemble the original work, and the second defense is going to be, teachers train writing students based on works as example and use it as text, so what's the difference?
That's a very good argument, because there is a legal copyright carve out for education. If you're using the material strictly for education, not for economic gain, and you're reproducing it in copies for educational purposes, such as a teacher in a classroom, that is not a copyright infringement. So that is a very good defense. Yeah. Yeah. Okay, so we talked about, yeah. I know some of you guys asked, what happens if you get sued for defamation or copyright infringement? Definitely consult with a local attorney. I would not advise you to handle this yourself. As we talked about, a lot of cases just don't have legs, are frivolous, are sometimes just designed to get you to do something, not necessarily to get a judgment against you. So an attorney will be able to advise you if the case has merit and what you can do. But I would, like, I'm an attorney, I would not defend myself. I would hire somebody else and outsource that, somebody else who litigates this in their daily practice. But it's, yeah, pretty difficult to, make it so that you can never be sued. I mean, there's always a risk. What you can do is mitigate and reduce the risk. That's what I try to advise people about. Yeah.
And also, always flies around the internet is, can you use a song lyric, one lyric? Can you mention the word Coca-Cola? Can you mention restaurants by name? What is open game and what isn't?
Yeah, good point. So for trademarked products, like you just mentioned, yes, you can use the name of the product, right, in your work. And then in the front matter of your work, you can say all trademark products are, property of the trademark owner or something like that. That's what we advise you to do, right? So that's okay. Using trademark terms is fine. Using the names of songs are fine. They listen to AC/DC's Thunderstruck. That's fine. You don't need permission to request use of the song title. You do need permission to use the song lyrics. Okay, that's a big difference. Yeah. Yeah. And there is no like minimum regarding the song lyrics. There's no legal minimum you can use without having to request permission. Obviously, it has to be identifiable, right? But yeah, you're still gonna have to request permission to use song lyrics. And for song lyrics, all music producers have to belong to one of three different companies. So what you do is you go search on those companies' databases to find out who is the copyright holder of the song. It is rarely ever the artist. It's always like some producer or something. And then you have to contact them, and they have a process that you can follow to request permission to use the song lyrics. Copyrighted song lyrics. It's usually a long drawn out process. There's usually a fee involved. Yeah. Things like that. So yeah, I mean, I've done it myself, and the process took so long that I just abandoned it. And I said, I'm not going to delay publication anymore just to use these lyrics. So that happens too. You can, if you don't get an answer from a copyright holder on the song lyrics, you can use the lyrics and make a statement like all reasonable efforts were made to secure permission from the copyright holder. I don't advise that because I'm risk averse. I would just not use the lyrics, but that is a possibility. Like if the copyright holder has not, if you've reached out, they have not answered you, it's been like a year, you can, that's one option you have, is to go ahead and use the lyrics and then make that disclaimer. But again, it's not something I recommend because it still opens you up to liability. And the copyright holders of lyrics, the music producers, have a lot of money to litigate. So
on all forms, I know a lot of poetry will just use lyrics directly. So that's not a good thing.
Correct. Yeah. If you're using song lyrics and they're identifiable from a song, you got to request permission from the copyright holder. Yeah. Even if you give credit, right, you still have to request permission.
I think Leanne has another question in the chat. If the book is under her company's LLC, can she personally be protected from being sued?
Great question. Okay, I love this question because I love the talk about limited liability. Yeah, so I think it's a great idea to set up your own LLC publishing company and publish through that. It does lower some risk. It does not eradicate risk. So the answer to your question is it depends on the nature of the suit. If they are suing you in individual capacity for something you did, if it's something you did as an author, or a publisher, possibly the liability will be limited to LLC assets. So it really depends on the nature of the suit. But the LLC does protect you. It just depends on the nature of the suit, what they're alleging, and if they can get around that LLC corporate form. It can get very complicated, but yeah, it's a good idea to incorporate or have an LLC to limit liability. Yeah.
So if something is published, does it automatically have your copyright? And I'm not even talking about books. People throw up their work on, sometimes they do actually throw up their work on blogs or on Facebook. Is it considered your property if you put your poetry or your story or an excerpt from your memoir on Facebook?
Yes, you're still the copyright holder. Yes, absolutely.
All right, good to know.
Yeah. Yeah. You don't give up your status as copyright holder just by posting it online, your own work, if that makes sense.
So
Okay.
I was accused of copyright infringement once. It's an interesting story. It didn't have anything to do with the literary work. It had to do with an image I found doing a Google search.
Oh, interesting.
First of all, I have to understand that my day job is being a tax preparer.
Okay.
I used to have a blog, and I used to put things on the blog, and I always used to like to put images with them because they gather more attention. So I found an image of two tax forms that were one crossing the other, and it looked interesting. The forms had to do with the topic I was dealing with, and I put it on my blog. And I was contacted by one of these trolling online attorney firms asking if I wanted to pay $10,000 for the use of this image that they were representing the copyright holder. So I hired an attorney, and the attorney asked me how much I'd be willing to pay to settle. And then I started doing my own research. And I found there's a federal statute that says nobody can copyright a federal work. So that means the federal government can't copyright it. No other government can copyright it. No firm, no entities can copyright it. No persons can copyright it. So I sent a email to my attorney, and I said, I'd like them to pay me $10,000 for, the aggravation they've given me because this work is not copyrightable. But I later found I took the image that I used and I put it in a Google image search, and it came up all over the place with a copyright notice on it from the Associated Press. And so apparently the Associated Press thought they could copyright a federal work. So of course, my attorney would not pursue getting me damages because attorneys don't do that sort of thing, So we pointed this out to the trolling attorney firm, and they just went silent. It's been 10 years now. I never heard from them.
Yeah, that does happen. They just want you to take it. They want to scare you into taking it down. A lot of the times, if you do a little bit of digging, they don't have legal legacy on it. Just depends. Yeah, so that's interesting.
Anyone else have any questions about? Yeah, there's a lot of protected photographs, so it sounds like ambulance chasers may go after you. Any other cases, Maria, that you feel would be pertinent to writers or this group?
We've mentioned the two main ones. The copyright one was a big one because that's, it highlights that they're the one indicating that, where the court found that your work is protected under the statutory damages when it's registered with a copyright office, not when you file. So that underscores the importance of, as soon as your work is finished, filing ASAP, right? Now you have to have a finished work to be able to file with the copyright office, not a draft. So that's an important point. So that's a really important one. The AI case is important. And there haven't been any other recent cases I can think of. that would be helpful in looking at circuit court cases. But of course, that, you know, the Johnny Depp case was regarding defamation. That's interesting because the standard to prove defamation is much more stringent if you're a public person or a well-known person. So that's something to point out. Like if you're writing about somebody very well-known, they have to, it's harder to prove defamation, right? Because they're a public person. So that's something interesting to what we're talking about here. Yeah, that case was just down the street from me in Fairfax, Virginia. So I was like watching, it was fascinating. I mean, I could talk about that case all day, and it's not super pertinent to authorship, but it is pertinent regarding the defamation, because the subject, the statement, which was the subject of the defamation trial, was reproduced in a newspaper. It was a written work, so it was a libel suit saying he was abusive, which is a defamatory statement, right? So, and it did, allegedly impact his ability to get and keep employment. So that's a really good example of that trial. Yeah.
Another question, a question regarding getting the rights to someone else's story. What besides a non-disclosure to you, do you need when you approach or talk to that person?
Okay, so you're writing a nonfiction book about somebody else, like a biography? Is that what we're talking about? Okay. Sorry, go ahead.
I'm sorry, this is mine. No, I
Okay.
want to go and get the rights to a couple of people I know, their stories, and it would be, true or however they wanted to do it.
Okay.
So I know there's like a non-disclosure, but what else do I need to?
You need a contract. You need to draw up a contract, including the non-disclosure.
Okay, so what in a contract includes, like, what?
That so you are. I mean, this can get complicated because you're writing about them, and again, you're in Georgia. You said, right?
Yeah. Well, I live in Maine, but these are
Okay.
these are ex-clients of mine, and both of them are in Georgia.
Okay.
And both of them are in jail. Put it that way.
Okay. Okay.
And their story, and there used to be clients of mine, and their stories are very national, but they haven't written books yet. And I would like to be the person that writes their book because I know them intimately.
Rights to a story. Okay. So what? Yeah, I'm not sure if you can do that. So if, for example, you write a book and you sell the rights to the written work to, for it to become a movie, that's one thing. If somebody there's no written work, right? They haven't written anything. Is that right?
Correct.
So I don't know that legally you can get the rights and prevent them from writing about it.
No. I'm going to go they're like, I know them personally.
Okay.
And they're pretty famous, and they're both in jail, but they used to be clients of mine.
Okay.
And I was their real estate agent during the times where they committed the stuff that they're in jail for. So, and I've checked that nobody has done their books yet. And I think that I know them well enough. And I know that, like, with Anna and what I'm doing, that I literally could go to the jails and talk to them about writing their story, which would actually help their story. But I just want to know what I need to go in there with ahead of time.
I mean, a local attorney is going to be able to advise you more specifically, because this is the type of thing where you're opening yourself up to defamation, like we talked about, right? Even if it's true, what you're writing about is true, they can still sue, and now you're litigating truth, right? And that can be costly. So different attorneys will tell you different things about whether or not you should request permission from a subject to write about them. The problem with going to a subject and requesting permission and getting their sign off is that you've admitted, I'm writing about you, right?
Well, I would have to, because I would be actually interviewing them. What I'm offering them is, I will write your book for you. And based on my background and stuff like that, I could actually do it. And so, but before the defamation stuff, I just want to know, to protect me, what I need to go in with. And it sounds like what you said, like a contract that says, I will pay you X on X, and then you have to exclusively work like a ghostwriter, right?
Right, exactly. Yeah,
Okay,
and
and
you'd have like a hold harmless, like they agree not to sue you. Now, I will say in some jurisdictions, courts don't like people giving away their rights to sue. So that's where a local attorney can, like, where I would start where you live, like get a consult with a local attorney about that. Like if they sign a contract saying I'm giving away my rights to give up my rights to sue for potential defamation XYZ, some courts don't like that and won't recognize that. Okay, so that's something I would just caution you about. But yeah, you would need a contract with like a non-disclosure, with a hold harmless, with all these things. Ideally, that's what you'd want. Whether a court will honor that if there's a suit, that's a different story.
okay. And then in terms of like anybody else that's associated with the story, do I have to do the same thing for them or just the main person who gives me the rights?
You don't have to. I mean, you don't have to. You can. Yeah. Again, it doesn't prevent anybody from suing
right.
you. They can come back and say, "Hey, I never said that." But again, when they can say, "Hey, you lied about what I said," but if your statement that you published is not defamatory, there's no suit. Does that make sense?
Yeah, and
you
then just
say, "Oh, yeah, he, I don't know, went to X city on X day." If that's false, that's not defamatory. So there are many pieces here.
And then just to understand, even though these people are incarcerated in Georgia, I live in Maine, I would get a Maine attorney, correct?
So I would start with the Maine attorney, yes. Now, if these people were to sue you, they could sue there, they could sue in Maine. It depends where they can get jurisdiction, okay? So where a plaintiff can sue depends on where people reside, where the action happened. In the Johnny Depp case, they sued in Fairfax because the Washington Post servers are located here where I live.
Okay.
That's why they were able to sue here. So getting jurisdiction is a whole different conversation.
Okay.
Yeah.
That's perfect. Thank you.
Okay, no problem. Anybody else? That's all like the prepared material I have, but I'm happy to talk about other things or answer questions if we still have time.
All right, so Ray's got, does the federal government rule extend to actual government agencies? Can we write about the FBI or CIA without getting sued?
Yeah, if you can get it through FOIA. But I mean, a lot of that stuff's redacted, that you're not able to get that information. Yeah, I mean, but if whatever is what we say FOIAble, subject to Freedom of Information Act, and you can get, yeah, you can publish. But a lot of that stuff's redacted. You'll be able to
like a work of fiction, though.
Yeah, in a work of fiction, yeah, you should be able to, if you've got it like through FOIA or it's just available on a government website, you can publish that. Yeah.
So let's say I want to write about a rogue FBI agent and I don't want to do any research about the actual FBI. I just want to make it all up.
Oh, so you're going to make it up?
Yeah.
Yeah.
It's a work of fiction.
You're talking about like defamation risk?
Yeah. I mean, is the FBI going to call me up and say, you can't talk about us like that?
No. Okay. There would be no basis for suit. Yeah.
Okay.
No.
And then just along the lines of, I've heard so many different things about, having your characters drink a Coke or drink a Budweiser or whatever, and that's okay. And but music seems to be a little persnickety. Can they wear a Foo Fighters T-shirt, or a Tom Petty T-shirt?
Yeah, that's fine. You can mention the name of a band, no problem. Yeah.
Okay.
Yeah. I like that you mentioned Foo Fighters because Dave Grohl grew up down the street from me too.
That's right, Fairfax. That's right, he did.
He's from Springfield, yeah, which is like literally down the street from me. Yeah. So.
Well, I actually have a protagonist who quotes a lot of philosophers, and he quotes he says a quote to somebody, and they say, "Oh, who is that, Thoreau?" He goes, "No, Tom Petty," and it's a line from a Tom Petty song. So now I guess I have to go get permission to use that. Fortunately, Tom Petty's his old photographer lives in the same city I do. So.
Oh, there you go. Yeah, so there you can search on what are the 3 companies that music producers have to belong to, and then you can search for the song, and then you can see who the owner of the copyright is, and then you can contact them directly. Yeah.
So ASCAP, BMI, are those 2 of them?
Yep, ASCAP, BMI, and SESAC, SESAC.com. Yep.
All right, thank you.
No problem.
Any other questions? All right. And there's some product placement in movies. And also, could you put the music acronyms in the chat?
Yes, I'm going to do that right now.
Yeah, and I just had a quick regarding product placement in movies, you know, like you just said, t-shirts or whatever, that has to be negotiated, right, with the
Yeah, so that's
company.
yeah, that's outside the scope of like the written work. Yeah.
Okay.
Yeah. There was a big a good example of that was let me finish up this ASCAP.com. The movie Scream, you know, the ghost face mask. That was a good example of that. They had to negotiate using that because that was not copyrighted, but it was a trademarked product. So they had to negotiate use of that.
And that was big money too.
That was big money. Yeah, that was big money.
Or the scene in Better Call Saul with the for the banking, for the financial place, the drawing of the horse.
Oh yeah, that's right. I forgot about that. Yeah, those are really good examples. Yeah.
Same question.
Go ahead. Sorry.
Same question I had for federal government agencies about colleges and universities. Okay, to have them wear a Florida State baseball cap or Duke
Oh yeah.
sweatshirt, stuff like that. Okay.
Yeah. I mean, you can mention teams. You can mention. Yeah, that's fine. That's no problem.
All right. Anything else, folks?
I'm gonna put my email here.
That was awesome. Thank you so much.
If anything else comes up, no problem. This was really fun. Thank you guys.
Thank you. It's totally
We'll head
helps.
out and happy writing.
Thanks so much, Maria.
Thank you,
No
Maria.
problem. Take care. Take care.